this morning's docket. That is case number 116423, State of Kansas v. Roy Samuel.
May it please the court, Peter Meharry for Roy Samuel. If I could request 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted.
Thank you. This case comes before this court after the district court denied Mr. Samuel's motion to correct an illegal sentence. By way of background, Mr. Samuel was charged in December of 1997 with murder in the second degree. At that time, murder in second degree was an off-grid offense. There was a short window where murder in the second degree was an off-grid offense before it's been moved back to the grid. He pled guilty, was sentenced to life with a minimum of 10 years before parole eligibility. Since that time, he has not been paroled, and in February of 2016, he filed a motion to correct illegal sentence. He argued to the district court that recent U.S. Supreme Court cases, most notably the trio of Roper, Graham, and Miller, show that a life sentence for an individual who was a juvenile at the time of the offense, and in this case, Mr. Samuel was 16 years old at the time, such a sentence is unconstitutional. The district court, after receiving the motion, denied it, basically kind of two reasons. Number one, the district court found that a motion under KSA 223504 could not raise claims that a sentence is unconstitutional. Secondarily, even if it did consider the merits, it found that what the U.S. Supreme Court has said is life without parole for juveniles is unconstitutional, and it noted that Mr. Samuel had a parole eligibility date set. It was 10 years when he was sentenced, and certainly has that option as time goes on. So the issue before this court are the very same two issues. Number one, whether or not it should address the merits of his argument, and then number two, if it does address the merits, whether or not a life sentence, even with the option of parole, is unconstitutional when it's applied to an individual who's a juvenile at the time of the offense.
So you're not going to correct the sentence, are you? I mean, the sentence is legal under the statute. You're attacking the statute as being unconstitutional.
Our argument is that the sentence itself is unconstitutional. It's substantively unconstitutional. And going back to Montgomery v. Louisiana, it talks about certain sentences cannot be imposed on certain individuals under the Constitution. And in those instances, those are substantively unconstitutional. It is beyond the power of the court to impose. So we are arguing the sentence itself is substantively unconstitutional, and it could not be imposed when it was. And under Montgomery versus Louisiana, this court cannot let it stand. It must give retroactive application to Miller and Roper and Graham and find that it is unconstitutional. And as I said, could not be imposed at the time, nor can it stand today.
But it doesn't, I mean, part of the problem I've got is you're not saying that this sentence is clearly per se illegal under the Graham-Miller line of cases because those facts are different, right?
There certainly is a very clear distinction between what those
You have to extend the case law to a different set of facts to get the ruling that it's unconstitutional when your client has a 10-year mandatory with parole, as opposed to lifetime without parole as a juvenile.
Certainly, what Miller held was life without parole is unconstitutional, and what we are arguing is life even with the option of parole is still unconstitutional when it involves
So what's
a juvenile.
required under the motion to correct an illegal sentence is you want to have a whole full-blown argument over constitutional law and trying to apply it to a different set of facts within the confines of this statutory procedure. And that we have consistently said you cannot do, right?
That's not exactly what we're arguing, Your Honor. What we are saying is there is a category of defendants and a category of classes of punishments that is beyond the power of the court to impose. It is unconstitutional. We aren't saying the facts, the individualized facts of this case show that the sentence is unconstitutional. It's a category
But
of
it's the facts
defendants.
because you have to extend the legal argument to get to this set of facts. 10 years with parole versus life without parole.
Maybe we're just semantics here.
I don't think it's semantics. I mean, I think what you're wanting to do is use this statute as a mechanism to litigate a legal point that has not yet been established 100%. In other words, this isn't a juvenile doing life, mandatory life without parole, where you could say, look at Graham, look at Miller, this is an unconstitutional sentence. You have to say, look at this, how they applied this legal argument, how they got there. This would be the same thing. And my point is, we have consistently said this statutory procedure is not there to litigate that point, right?
What this court has said is that constitutional claims cannot be brought under 2235-04. And I think
So what do we do?
I think here there's a difference because we are talking about things that are substantively unconstitutional. We aren't talking about procedural issues about what procedures used to get from the charge to the sentence. What we are saying is this sentence that is imposed cannot be done with this category of defendants.
Are you saying that this fits? I mean, we've traditionally had 3 categories of illegal sentences. Are you arguing for a 4th category, or are you saying this fits the 1st category, which is the court lacks jurisdiction?
I think it falls under that category, that if the court has no ability, no power, or no authority under the statutes or the Constitution, as we've argued here, it has no jurisdiction to impose
and
that
just to
sentence.
clarify, are you making an argument in the alternative that there might also be a 4th category? Or are you limiting, does your case rise or fall on this jurisdictional question?
I would say argument 1A is that there's no jurisdiction for this sentence to have ever been imposed. Argument B certainly is, and what Montgomery has said, is that if a sentence is substantively unconstitutional, a court can't let it stand. A court could not impose it, and it can't then ignore it and let it stand because it is something that is beyond the power of the state to impose on a defendant.
My follow-up question in what you termed 1A, I guess it's really basic. Doesn't by logical necessity that mean that every time a court takes an action that's unconstitutional, somehow it was acting without jurisdiction?
I don't believe so because I think there is a distinction between procedurally unconstitutional and substantively unconstitutional. I think that was the heart of Montgomery versus Louisiana, is that when they talk about something that is substantively unconstitutional, it is whether or not it's an act, private act, or a sentence, it is simply beyond the control or beyond the power of the state to impose. Where when you talk
Well,
about
if something's unconstitutional, isn't it beyond the power of the state, whether it's procedural or substantive?
when it's procedural, that is something that is used to kind of enhance and ensure the accuracy and the fairness of the proceedings. And I don't think that it necessarily makes everything done, even if it's procedurally unconstitutional, I guess void. Because this court certainly finds all the time constitutional problems
That's the problem,
are
right?
harmless.
Right. How could it be harmless if it was actually depriving the court of jurisdiction?
Right, and I think that's the difference when you get into substantive issues here that we are arguing, is that when it's substantively unconstitutional, at the outset, the court has no power to do what it did. And in this case, what we're arguing is that it had no power to impose a life term even with the possibility of parole. And certainly we recognize that that is extending Miller, because Miller specifically talked about life without the possibility of parole. But I think when you look at this court's opinion in Dahl, the same analysis should apply to a life term. This court talked about, in that case, post-release supervision, lifetime post-release supervision, and about the onerous restrictions, onerous supervision that come along with lifetime post-release supervision.
Where do you, I'm sorry, counsel, go ahead and finish your thought.
I was just going to say, Mr. Samuel faces the same thing. He will be under the state supervision for his entire life and will have all those same type of restrictions that this court talked about in Dahl for his entire life.
You don't
I
know
was
that.
going to ask, how tightly is this going to be boxed in? For example, is it possible that somebody could say, well, I know what Miller v. Alabama said, but I think it's also unconstitutional to have this apply to somebody who's age 20. Is that something they can bring under a motion to correct a legal sentence?
You know, as far as where the next case goes, I don't know. What I can tell the court is that the U.S. Supreme Court has certainly talked specifically about the differences with juveniles. And as far as I know, every place talks about juveniles being under 18. If there's an argument that that should be changed, you know, I'm sure somebody will make it. But what we're arguing in this case is that Mr. Samuel was all of 16 at the time of these offenses. He was clearly a juvenile, and imposing a life sentence on him, which includes both the prison term and when or if he's paroled, all the supervision that comes along with it, is unconstitutional. I don't know if that answered your question.
It does. I just have concerns that this statute now becomes quite large in terms of claims that a defendant's going to be bringing, as long as it is under the heading of it's unconstitutional.
You know, I think what we have argued, and what I probably said substantive a lot right now, but what we have argued is very specific as far as categories of defendants and categories of punishment that are beyond the power of the court. And I don't think that is overly broad. But I would also argue that the statute 223504 talks about correcting a sentence at illegal sentence at any time. And I think, frankly, that should be broadly interpreted. We don't want illegal sentences. One of the points of the guidelines is to have consistent sentences. And if we have illegal sentences, that undercuts that on top of the simple unfairness of it all. So certainly we've made a specific argument in this case, but I don't see necessarily the downside to people arguing and this court finding this is an illegal sentence and we need to correct it. I think it goes to the point of the guidelines, and I think it also goes to fundamental fairness. But for our purposes today, we are focused on juveniles who are children or young adults, very young, at the time of their offenses and are facing this life sentence. And as this court talked about in Dahl, it's certainly widely recognized that juveniles are less deserving of and less culpable than adults and don't deserve the harshest of sentences.
But didn't the Montgomery court indicate that the remedy for a Miller violation was to provide an opportunity for parole for those juveniles? So doesn't that just undercut your argument that the case can be extended to your client's situation?
That was the argument, or the ruling in Miller. Certainly concede that what they said is they need to have individual sentencing and opportunities for parole. But this court has said even if you're out on parole, even if you're under state supervision, that still is unconstitutional when applied to juveniles.
But now you're extending your argument for jurisdiction beyond what the U.S. Supreme Court has said courts don't have the power to do.
I'm arguing
To an Eighth Amendment analysis. So aren't you, I mean, you're moving past your jurisdiction argument, it seems like.
I don't believe I'm moving past my jurisdictional argument because I'm arguing that this still is substantively unconstitutional. and that brings it under 223504. Certainly, it is an extension of the argument in Miller, which dealt with life without parole. But given this court's opinion in Dole, the findings that this court made about the restrictions and infringements on liberties and freedoms that come with simply supervision, even if you're not incarcerated, I think that this court still should find that life in prison, even with the option of parole, still is substantively unconstitutional. It's a class of defendants that can't be punished in that certain way.
Justice Byer, I cut you off a minute ago. You still have a question?
Well, I was just going to point out that generally along the same lines as Justice Lukert, that a possibility of parole makes this case entirely distinct from the one on which you place your reliance.
I think the possibility of parole does somewhat distinguish it from Miller, but I don't think it distinguishes from Dole. And this court said, lifetime post-release, that itself imposed on a juvenile is unconstitutional. This court did not look at the prison term in Dole. It looked at when he or she, I think it was a he, was released and under state supervision. And even if Mr. Samuels gets parole, he will still be under state supervision. And that is what this court found to be unconstitutional in Dole. I think that's how it applies in this case.
Do we have any further questions? Thank you, counsel.
Thank you.
May it please the court, Ethan Sigler from the Willamette County District Attorney's Office. I think kind of going to the first point about whether the court had jurisdiction, whether this is a jurisdictional question at all, if we look at Montgomery, the fact that Montgomery says the solution if a juvenile is sentenced to a life without parole sentence is not a resentencing, but granting the opportunity for parole tells us that that is not an illegal sentence. It was an illegal sentence and it was imposed without any jurisdiction whatsoever. The remedy would be to send it back to the district court to re-sentence it within a legal sentence. But what the Supreme Court of the United States said is give the offender an opportunity to be heard by the parole board. They did not say that it needed to be resentenced. In fact, they say it does not. So what that tells us is that it does not create a new categorical right. It does not place this defendant inside of that categorical right, and it is not a new substantive constitutional issue that he needs to be allowed to correct in a motion for a legal sentence. And I believe because of that, Warrior and Mitchell and McPack, I'm sorry, I can't pronounce that, are all still good law. The motion to correct an illegal sentence is not the proper mechanism to bring this challenge, and it should have been denied procedurally before we even got to the merits. Going to Dulles, I think we have an entirely different issue. Again, in Dulles, the issue is that the juvenile offender is never given an opportunity to be released from the custody of the state, even though that custody is supervision and not the actual custody of the Department of Corrections. It's a lifetime sentence. It never ends. But that is not the case here. Mr. Samuel's sentence has the potential to end. It's not guaranteed, but it definitely has the potential to end. He could be granted parole, and that would lead to the end of his sentence. So we have
What's the duration of the parole, though?
And I did not look it up in this case. And if it is lifetime, that would trigger Dulles, but for a different reason, and it's a different argument that was made in this case. So going just on the sentence itself, the sentence of incarceration, which was challenged here, I don't believe that can be brought in a motion to correct a legal sentence.
Let's say, counsel, that you have a case which is a slam dunk on the Eighth Amendment in the defendant's favor. What's his remedy?
I've actually been thinking about this for a couple days while I've been prepping for this, and I'm not sure, but the logic of Warrior and Mitchell is very specific that the motion to correct a legal sentence is a statutory provision.
Right, let's say we agree with you. And let's say, again, I'm positing the difficult case where you have a clear Eighth Amendment violation, and There's no remedy available via the statutory motion to correct any illegal sentence. Where does that leave the defendant?
My gut reaction is some sort of habeas petition, and I know those are also bound by statute, but that's kind of where I was in my head where I think it would be more appropriate. I don't know, though. I certainly have tried to come up with an answer to that because I suspected that would be a question, but I'm not sure I have one. Now, going on to the substantive issue of whether or not, assuming you reject my argument that this can't be brought in a motion to correct the illegal sentence, I simply don't believe that the standards of the Eighth Amendment cover this case. The community norms have not evolved in such a way that we believe that given a meaningful opportunity for parole, that sentence is cruel and unusual. And I think the actual extension that we should talk about here, and Justice Nuss mentioned, would we extend this to 20-year-olds, is actually the opposite way. We have many juvenile offenders who meet the criterion for a criminal history B or an A, and if those juvenile offenders at even the age of 16 or 17 were waived to adult status on a second-degree murder, they would be facing a determinate sentence of around 50 years in the Department of Corrections. That is a determinate sentence. It cannot be terminated early, minus good time credit. And there has still been no extension of Montgomery and the Supreme Court cases to a determinate sentence, even though those determinate sentences could be well in excess of what an individual got on an indeterminate lifetime sentence. Because of that, there's no community consensus around a number that's appropriate for a juvenile to serve. There's no community consensus about the morality of how long we can keep a juvenile incarcerated. And because of that, the Eighth Amendment would never come close to being triggered on an indeterminate sentence where a juvenile is given a meaningful opportunity for parole after 10 years. And because of that, the Eighth Amendment, even if you got to the substance of this issue, the Eighth Amendment would not apply to Mr. Samuel's case, and therefore the case would not be an improper sentence under the Eighth Amendment. I think that's about all I have myself. If you have any questions for me, I'd be more than happy to field those.
Do we have any questions, counsel? Thank you, counsel.
Thank you.
First point I want to make is opposing counsel talked about Dahl being a lifetime post-release case, and then talked about my client's sentence ending when he's paroled. I don't think that's correct.
Do you know the duration of parole? Is it a lifetime parole?
My understanding it's lifetime parole.
It is typically with a life sentence on
Right.
the adult side. Is that what it is here?
That's certainly my understanding. He was tried as, or I guess he pled, but
Right.
got a life sentence. He doesn't get a day when he's not under state supervision. So in that sense, I think it is essentially the same as Dole.
But Dole wasn't a murder case.
Dole was not a murder case. It was, I believe, a sexually violent offense.
And we consider both the offender and the offense, don't we? When we consider Eighth Amendment categories.
Certainly, you consider all the facts and circumstances, I believe. And in Dole, you talked about whether or not there was a national consensus. And then this court did look at its own independent judgment about whether or not that sentence was unconstitutional as applied in that case. And the conclusion I think this court came to was that what was most important in Dole was that he faced lifetime post-release supervision as a juvenile for a crime he committed when he was a juvenile. The overriding fact, at least what I get out of Dole, is that this court found that sentence was unconstitutional because Dole was a juvenile. And imposing that lifetime sentence on a juvenile was what tipped the scale. And we believe that is the same situation we have here with Mr. Samuels.
How is your claim ripe?
I'm sorry?
How is your claim ripe on the lifetime post-release?
parole.
He's not out, he's not on parole.
He is not. Our argument is that simply imposing a life sentence where it's lifetime, either incarceration or supervision, is unconstitutional when it's applied to an individual who was a minor at the time of the offense. So we believe that even if he's sitting in jail, or even if he's on parole, he's still under a life sentence, and that is what is unconstitutional. And therefore, it is proper for this court to look at it now.
Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.